Good morning to everyone present. My name is Ankit Malhotra. I am a Felix Scholar from SOAS, and I am now currently working as an associate in the Chambers of Justice, A.K. Sikri, former Judge, Supreme Court of India, and a international judge in the Singapore International Commercial Courts, and also a member of Four Pump Court, a chamber in London. Um, this paper, and in fact, the motivation to work on a topic such as this really stems from my current legal practice of litigation, but also sustainable frameworks, and is really born out of a speech that I had worked with for and with my boss on climate financing and green litigation, especially in a comparative analysis. And this paper really is a reflection, or in some sense, a growth on the topic that one encountered in such engagement and interaction. To begin with, I'd like to focus on the following areas because they provide, in some sense, a framework or at least a design as to what the sustainability agenda is, what is the importance of such litigation in enforcing standards of sustainability, and therefore, in some sense, encompassing the wider framework of this paper. Now, having said so much, it is important to reflect on these key instruments, such as the Treaty on Functioning of the European Union, which enshrines environment protection as one of its objectives, more specifically in Article 11.1. To build on this, also important to consider the EU Charter on Fundamental Rights, which recognizes the right to an environment that is protected but is also improved. And it is this point that we shall now return to at a later stage, but it does so in Article 37. And by doing this, it provides a comprehensive body of environmental directives and regulations that address specific environmental concerns, such as those which we hear about perhaps on a daily basis. The EU has been at the forefront and has intensified significantly its efforts towards sustainability by integrating all aspects of economic and social policies. And this is important in the initiatives such as the Green and European Green Deal, which is a strategic roadmap for making the EU's economy sustainable through investment in clean technologies, sustainable industry, and building on renovation. This all has been communicated by the directors of the Council of Europe, the European Green Deal, the European Economic and Social Committee, and the Committee on Regions, and perhaps most importantly, the communication from the Commission of the European Parliament. The taxonomy, therefore, in this regard, especially in regards to the regulations, which establishes classification systems for sustainable activity, especially under its regulations, and the European Parliament's Council's decision on the 18th day of June 2020 on the establishment of such a framework on sustainability and amending these regulations are important pieces. However, this is where we are now. But when did the journey start? The journey really started back in 1972, with the United Nations Conference on Human Environment. There has been significant processes and stewardship in international environmental norms, but also the frameworks which we now understand as common knowledge. But this was not without public participation and the culminative harm that we have suffered. For that is important to emphasize the respect for national systems and also the well being of human beings and communities. The legal and ethical foundations, which are not merely pronouncements, but are grounds for the human condition and the recognition of the human's existence within the ecosystem. This objective reality is understood through social scientific measures from the environmental laws and their enforcement agencies. But that perhaps is not all. For the soft law instruments, such as the Stockholm Declaration, the World Charter for Nature, and the Earth Charter, are important documents that reflect a global and growing consensus on environmental law principles and the need to enforce them. But that, again, is not all. For enforcement of international legal instruments also needs to be put into the domestic systems. And a leading example of that perhaps could be noticed in the Administrative Procedure Act of the United States of America, which facilitates public participation and judicial review. These essential components help in enforcing environmental norms and procedures. There are also important initiatives like the IUCN and also the UNEP, which are aimed at legal administrative capacities across nations to enforce these laws. What about the Aarhus Agreement on access of information, public participation in decision making, and access to justice in environmental matters as a significant step towards strengthening the enforcement of law and environmental governance? It is therefore the objective of this paper to look at litigation and enforcing sustainability standards within the EU, the various mechanisms through which these litigations are enforced, and the sustainability agendas that they follow. The challenges that are associated with such litigation also help in enforcing litigation and the outcome of such litigation. This paper on illustrative case studies will demonstrate how litigation is being used to enforce sustainability standards within the EU, and it will refer to cases such as the Urgenda Foundation versus the State of Netherlands, wherein a group of NGOs successfully sued the Dutch government for failing to adequately address climate change. It will also look at Movers Commission, a case where another group of NGOs challenged the EU's adoption on regulations of fluorinated gases. These perhaps are just few of the examples that the paper shall refer to in order to provide a comprehensive overview of the topic of exploring these changes in the environment. But it is therefore also important to look at the legal instruments that the cases offer and also touch upon. For the European Convention on Human Rights in the European context is seminal, and that brings to mind the discussion on the Le Mouvement Écologique versus France, which was brought to the European Court of Human Rights and established the right to effective remedy for environmental breaches under the European Convention on Human Rights, and it goes back as far as to 1998. Another important principle that one must refer to is the public trust doctrine as a common law principle that holds that the governments have a duty to hold certain environmental resources in trust and benefit of the government. But what about the United States of America and the public trust doctrine that has been applied to challenge government that permits activities that could harm public waters or wildlife? What about procedural aspects? Procedural aspects that should be enabling agents. And one could refer to from Rio to Rio plus 20, the evolving role of international environmental law by the review of European comparative and international law, which offers a comprehensive review of these resources. To my mind, the most important principles, the cornerstone principles of any such discussion are the environmental law principles enshrined in Principle 10 of the Rio Declaration on Environment and Development, and principles related to such, which include but are not limited to the Aarhus Convention that I had mentioned earlier, but also those that help in providing accessibility and resource management. But litigation on such fronts is also important because it helps in enabling and also helping in such litigation. That is why the 2014 directive on non financial reporting imposes larger public interest companies to report the requirements on sustainability related matters. Specifically, the Shareholder Rights Directive 2 of 2017, which promotes more long-termism in share ownerships and shareholder engagements. What this does is that it provides a closer look to the most recent EU legislative policies and reveals so far that the EU institutions try to achieve this shift towards sustainable economy, mainly and also perhaps indirectly through reporting requirements and regulation of financial markets. The sustainable finance packages comprise of the regulations on sustainability, related discourses, and financial sectors, which is specifically focused on sustainable goals as well. The taxonomy regulations are also established as a framework to facilitate sustainable investment decisions and also tackle greenwashing. A revision of these existing non financial reporting directives was necessary at the end of 2022. The Corporate Sustainable Development Reporting Directive number 16 was therefore approved. Its main objectives were as follows: extend the scope of reporting requirements within non financial information to all undertakings and all undertakings with securities listed on EU markets. Second, to ensure and assure the compatibility of non financial information and indeed increase the limits of flexibility in reporting methods, introducing a detailed and standardized mandatory reporting system on double materiality principle that is within the EU sustainability reporting standards drafted by the European Financial Reporting Advisory Group. Although this is expected to significantly improve the sustainability related discourse, it is not underpinned by any substantial obligation to consider sustainability issues in the EU decision making process. The EU Taxonomy Regulation goes together with the principles discussed above, specifically under Article 3, which sets out a classification established the criterion for environmentally sustainable economic activities against the investments analyzed in the NFTR parameters, which will be assessed in accordance with the European Commission's 2022 report. That is because under Article 9 of the taxonomy covers six objectives that mandate is for firms to contribute at least one actively, either through economic activities that contribute or have financially supported sustainable activities. These objectives are as follows: climate change mitigation, climate change adaptation, the sustainable and protection of waters and marine resources, the transition to a circular economy, pollution prevention and control, and last, the protection and restoration of biodiversity ecosystems. The taxonomy, therefore, also modifies specific items within these, introducing new financial disclosure requirements for products affected by these disclosures or periodic reports for sustainable investment or investments with social environmental characteristics. Specific requests for companies and asset managers is to report information on the proportion of the turnover, capital expenditure, or expenditure of larger non financial companies. It is therefore important to look at the supply chains in 2021 and the EU passed resolutions calling for corporate due diligence of these companies. Experts consider that the EU regulation will mirror existing regulations in the 27 member countries in many aspects. In particular, the important and larger contributors to the European Union gross GDP, such as France and Germany, a bottom threshold will be set for them. Other examples will also include Belgium, whose due diligence draft bill scope includes suppliers across its value chain. Therefore, companies must apply the risk management to them as well. The new rules on due diligence will follow the UN guidelines on business and human rights, which would include EU companies to verify their supply chains with respect to environment but also human rights. It is therefore probable that more countries would follow, and contingent on the Brussels effect that would incorporate the effects of international trade, and the private sector is required to adopt standards to operate in the region, therefore supporting the spread of EU craft regulations. Multinational companies and corporations will therefore be compelled to comply to the EU regulations as a price accessing market. But what about the litigation and the management of such sustainable models? The client Earth versus the European Investment Bank offers an important perspective. That is because Client Earth, an environmental organization, challenged the investment bank's financing of a biomass plant in Spain. The litigation highlighted concerns regarding the project's sustainability credentials and its alignment with EU's climate objectives. The case underscored the importance of rigorous environmental assessments and the need for financial institutions to align their investments with EU's sustainable goals. This litigation also exemplified legal challenges that can promote and prolong reevaluation of investment decisions in the context of environment sustainability. The regulatory function of litigation is also important. That is because these legal actions reinforce the frameworks and signal the EU's commitment towards EU goals and also social objectives writ large. The conventions that I have mentioned, therefore, above are also important as they underscore the importance of public engagement in environmental decision making and provides mechanisms for individuals and organizations to challenges of violations of environmental law. Therefore, cases brought by these NGOs, community groups, individuals against larger corporations or government bodies not only signal highlights or importances of grievances, but also bring broader environmental issues to the public's attention. Having said all this, it is important to now also consider that the creation, maturation of environmental law globally represents a significant stride towards our planet and the future conservation. The story which I reflected started in 1972 to the agreements and conventions we now have are associated closely with the enforcement of environmental law and the complex interplay between legal frameworks, governmental action, and societal participation. But they also serve as an important and vital tool towards holding entities accountable, ensuring that the principles embedded within the vast body of environmental law translates into actionable measures and outcomes. Public participation, therefore, is the backbone of effective environmental governance. I do want to now look at the challenges that are faced in such aspects. And perhaps the most important would be procedural hurdles, because these can range from restrictive standing requirements that can limit bringing forward the ability of a lawsuit or the complex legal processes that can deter public participation. The variance in procedural rules across member states further complicates cross border environmental legal action, potentially delaying or derailing these efforts. What about the lack of awareness among public and private shareholders about the rights and the mechanisms available to them for environmental protection through litigation? This knowledge gap hinders the ability of individuals and communities to engage effectively with legal systems to advocate for environmental justice and sustainability. However, that is not all, because there are opportunities which are presented by litigation. The first of these that I'd like to highlight is the advancing of EU sustainability goals. For litigation can act as a catalyst for policy change, regulatory enforcement, compelling governments and corporations to adhere to environmental standards and commitments. Judicial decisions can also set precedent that shape the interpretation and application for international environmental law in domestic courts. Public participation and accessibility to justice also is facilitated by such measures. It also promotes innovation through compliance and to compliance. That is because enforcing of the corporate sustainability due diligence directives ensure that companies not only adhere to environmental standards, but also proactively address the environmental impacts both within the EU and the larger corporate goals of the company. Therefore, at a comparative analysis, one is reminded of the words of one Rachel Carson, who once said, and I quote, "We stand now where two roads diverge. But unlike the roads in Robert Frost's familiar poem, they are not equally fair. The road we have been traveling is deceptively easy, a smoother superhighway on which we progress with great speed, but at its end lies disaster. The other fork of the road, and the one less traveled by, offers our last, our only chance to reach a destination that assures preservation of Earth." Having said so, it is also important to consider the report published by the IPCC Working Group in 2022, which has conclusively noted that humans are responsible for virtually all global heating over the last 200 years. Human activities, like the ones mentioned above, are causing greenhouse gas emissions and are warming the world faster than that at any other rate over the past 200 years, say even 2000 years. What are therefore the lessons that we can learn from other jurisdictions, or perhaps jurisdictions which are close to us? Exchange of legal ideas, adapting old laws, or adopting different measures, developing climate conscious judiciaries and tribunals focused squarely on such issues, enhancing the effectiveness of environmental law litigation, fostering judicial legacy and literacy on climate issues, encouraging collaboration on international and interdisciplinary issues. That is the future. For the development and clarity of legal standards is an important aspect that one needs to focus on. Lowering the barriers of legal standing is also something that should revise the criteria for allowing broader range of stakeholders, including NGOs and citizens, to bring cases forward. We should also strengthen the provisions under the Aarhus Convention that ensures full and effective implementation of the convention crosses borders. We should also encourage strategic litigation, and this is perhaps where the EU can stand as a leader. It can also stand as a leader for fostering collaboration between different parts of the EU and its neighbors. We can also monitor and learn, because establishing a framework of environmental litigation is important, but equally important is observation of these standards. And with that note of counterment and also of focus on measures that help in in accounting for observations is of significance as well. You have also been able to see these interesting artworks, which depict humans' intellectual and imaginative capabilities. And what these suggest are something quite telling, because they are not illustrative of sycophants or of firebrands. They are illustrative of we how, as a human conscience, believe and entrust where we stand and how we stand in the future. With those words, I thank the organizers once again for allowing me to present my perspectives and thoughts. Thank you.